1 minute, ma'am.
Yeah.
Good session 2 of day 4. Now I may request Dr. Ajita to welcome the speaker for today, Dr. Girija Sriram.
We would like to introduce the speaker of the session. Girija is a patent attorney and registered patent agent with over 10 years of experience in patent laws across a wide range of domains in science and technology. She focuses on handling issues related to patent, trademark, copyright, design, including searching, drafting, prosecution, licensing, and counseling clients on addressing IP management and formulating IP strategies. She is also a trademark attorney and an advocate. Additionally, she is a seasoned speaker and talks about intellectual property related matters at various conferences, academic and research institutions and corporates. She has a master's degree in science and holds PG diplomas in IPR law, bioinformatics, technology management, and business administration. She is an expert panel member of the WTO and Relay Cell of Viswanath Trade Promotion Center, Government of Karnataka. She is a patent agent for various institutes and colleges. She is also a facilitator for startups in patent Government of India. Ma'am, on behalf of the college management, principal, HOD, staff, students, we welcome you to the session, ma'am. It's over to you, ma'am.
Thank you, Dr. Ajita, for that warm introduction. I'll just share the slides. Yeah.
Yes, ma'am.
Is it visible?
Fine. Yeah, ma'am, fine.
Yeah. So shall I start?
Yes, ma'am.
Yeah. Good morning, everyone. It's a great pleasure for me to get connected with you all through this webinar. In this session, we will first focus on the overview of IPR and then move to the industrial design process. What are the essentials of trademark filing? And then finally, we will have the question and answer session. See, overview of intellectual property rights. So generally, I call this as a warm-up session because this IPR or the intellectual property rights is no more an uncommon phrase in India. See, you would have heard or read about IPR through different modes of media. So let me start with a very informal definition of what is an IP. So IP is used to describe the results of creative and innovative endeavors. See, we call it as intellectual because it is created by the intellect of the human mind, and we call it as property because like there's a tangible property, this intangible property can also be owned, sold, leased, or transferred. What are the different ways of protecting IP? See, any innovative product or a process can be protected through patents and brands can be registered under trademark. The literary, artistic, the musical works, photos can be protected under copyrights, and creative designs under industrial designs. Indication of origin can be protected under geographical indication, and any confidential information can be kept as a trade secret, and the layout design can be protected under Semiconductor Integrated Circuit Layout Design Act. A single product can be protected by many IP rights. I have just taken a common example of a pen. See, the pen as a product can be protected through patent, and the name of the pen can be protected under trademark. The composition of the ink, which you do not want to reveal, you can keep it as a trade secret. The style of the writing of the name can be registered under copyright, and the look and the feel of the pen can be protected under industrial designs. We'll now see the different facets of the IPR. So what's a patent? See, it's a patent is a document. It will describe the invention and it will create a legal situation in which the invention can only be exploited with the authorization of the patent owner. And the other most important IPR is trademark. So trademark is a sign that distinguishes the goods or the services of one person from those of the others. So trademark can be a word, it can be a letter, number, shape of the goods, color, sound, and even smell. And Yahoo Hodel is one of the very famous sound trademark which has been protected in India. There are 4 types of trademark: certification mark, service mark, collective mark, and trade dress. So certification mark is generally used to certify the goods. So I have given the example of ISO 9001. And service mark is generally used in service industries like a bank, insurance, airlines. And collective mark is owned by the organizations like Lions Club, Rotary Club. And the trade dress generally refers to the total package of the goods. The third important IPR is the trade secret. So what is a trade secret? Any confidential business information that provides an enterprise with a competitive edge. So I have given a few examples, the famous Coca-Cola formulae, any data compilations, manuals, financial information. And the main important characteristic of trade secret is it can be protected without registration, and that too for unlimited period of time. The elements of trade secret: it should have an economic or commercial value. It should generally be not known to others, and reasonable measures would have been taken by the holder to maintain secrecy in the form of non-disclosure agreements. GI, this is another IPR, and this is like trademark, but this is used on the goods that have a specific geographical origin, and it possesses qualities, reputation, or characteristic that are essentially attributable to that place of the origin. And these are some of the famous GIs of Karnataka. And the GIs are generally classified as agriculture, handicraft, foodstuffs, and manufactured. So I've just given an example under each category. The other facet of IPR, copyright. So the copyright, as a patent protects the intellectual works, copyright protects the creative works. So it protects the creative works of the authors such as writers, artists, architects, photographers, directors, and music composers. What are the types of work that can be protected by copyright? It can be a literary work, a musical work, or an artistic work, maps, technical drawings, photos, motion pictures, computer programs as such, and the multimedia products. And again, copyright, it protects only the expression of the ideas. And so the abstract ideas cannot be protected under copyright. And again, the expression has to be on the tangible forms, such as the paper or the canvas or the compact disc, as the case may be. And the copyright owner has the exclusive rights to reproduce, adapt, translate, distribute, publicly communicate, and publicly perform. And the related rights to the copyrights are the performer's rights and the broadcaster's right. So what I mean by performer's right is that if a TV channel wishes to broadcast a live telecast of a dance, then they have to get the permission from the dancer. And the broadcaster's right is no person can make a visual or the audio recording of a broadcast without the permission of the broadcaster. And one more important IPR is the industrial designs, which we will see in detail in the following part of our session. So the industrial designs protects the aesthetic designs that are applied to the articles. So it can be a shape or a pattern or an ornamentation or any other artistic aspect. And designs which have functional value or the utility value cannot be protected under industrial designs. For that, you have to go for a patent. So I have given an example, and if you see that if the shape of the car improves the efficiency, fuel efficiency of the car, then it is not protectable under industrial designs. So it's purely the aesthetic designs. So functional designs should be protected under the patent. And semiconductor integrated circuit layout design, this is protected under the Semiconductor Integrated Circuit Layout Design Act 2000. And what do they mean by layout design is, it is the arrangement of the transistors and the other circuitry elements expressed on a semiconductor integrated circuit. So the criteria for registration of the layout design is it should be original. Original means it should not have been a copied one, and distinctive means it should be distinguishable from the existing designs, and it should not have been commercially exploited anywhere in India or in a convention country. Convention countries means the countries which are parties to the Paris Convention. So it means that it should be novel. It should not exist in the public domain. And what is the term of protection for SICLD is 10 years from the date of filing of the application for registration. Having seen for SICLD, we can also see the term of protection for other IPRs. So patent, they are protected for 20 years from the date of filing, but you have to renew or pay the renewal fees every year. Trademark and geographical indication, they are perpetual, means lifelong it is protected, but every 10 years you have to renew it. And copyright, the term of protection is 60 years plus the life of the author, but there is no need to renew it. And design is, the term of protection is 15 years. So initially they will grant it for 10 years, and once at the expiration of the 10th year, you have to pay the renewal fee for the next 5 years. You can see the trend in filing of IPR applications in India over 5 years. See, this is the latest data available in Indian IP website. And you can see that nearly a 4 lakh application has been filed in the year 1819, and it has been a very quite remarkable increase from in the last 5 years. And out of 4 lakh, you can see that trademark has occupied a lion's share, followed by the patents. Then you can see copyright, designs, and GI. Yeah. So with this warm-up session, we will now move to the main part of our session now, how to register an industrial design. So as I shared earlier, see what I mean by industrial design. What do you mean by industrial design? See, it refers to the shape or a configuration. Configuration is the arrangement of the parts, or a pattern or an ornamentation or a composition of lines or the colors applied to any article. So, and it can be in a 2D form or a 3D form, but it should be produced by, that article should be produced by an industrial means, and it should have been applied to the finished article, and the final judgment is done by the high of the CA. The requirements of design registration. First, it should be original. It should not have been a copied one. And second, it should not be available in the public domain. Means it should be novel, new, and it should be distinguishable from the other designs. Means it should be distinctive. It should be applied to an article. Hello? Hello?
Yeah, ma'am.
I think the presentation is stopped somewhere.
It is an essential requirements for design registration.
1 minute, just see it. Yeah. Is it visible now?
No, ma'am. You stop the sharing. You share again.
Just a minute. 1 second. Is it seen now?
Yes. Yeah, fine, ma'am. You
I'll
can
go
carry on.
Yeah, I'll go ahead. Yeah. See, what are the essential requirements for design registration? So it should be original, not a copied one, and it should not be in the public domain that we say in a technical term as novel, and it should be distinguishable from the existing designs. That is called the distinctiveness, and it should be applied to an article and should appeal to the eye and should not comprise or contain any scandalous or the obscene matter, and it should not be contrary to the public order or the morality, and it should not be prejudicial to the security of India. So these are the very essential requirements for the design to be registered under the Industrial Design Act in India. So what are excluded from the scope of the designs? Say any book or a calendar or a card or a postcard. So these are all not protected under the designs, and any label or a cartoon or any principle or the mode of construction of an article. As I said already, any functional value doesn't come under this. Example of a chair. See, I have developed designed a chair where the arms alone are artistic. So I cannot apply only for the arms of the chair. So I have to apply for the chair as a whole. So parts of the articles are not accepted. And then variations commonly used in the trade. See, we call it as very minor variations. These are all not or the workshop alterations of an assembly. So these are all excluded. And mere change in the size of an article. See, change in the shape of an article, you can go for design, but change in the size of an article, just merely reducing the size or increasing the size is not under the scope of the design registration. And any flags, emblems, or the signs of any country and layout designs of IC, which I told that you have a specific IPR for that, and so it is not under the scope of the designs. Again, who can apply for the registration of a design? See, any person can apply, or a legal representative of that person, or the assignee separately or jointly. So when I say any person, it means that it can be an individual or a firm or a partnership or a small entity or a body corporate. So you have just 10 steps to apply for the design registration. So what's the first step? See, you have to find out whether any registration already exists. So this normally done by checking the paid website and the free website which is available in the internet, or even you can write to the design office and then ask them to find out whether such design already is registered in the design office. Once it is known, then you have to prepare a representation sheets of the design. For that, you have to identify the class of the design. See, there are 32 classes under the Locarno classification. You have to identify the specific. See, for example, I have come with a new design of a electric vehicle. Then I have to register it under the class 12. So, or I have come with a new design of a mouse. Then I have to register under the 14. So you have some specific classes for each article. So you have to identify that class. Then you have to provide a statement of novelty. Novelty is that I said it's a newness. So you have to say where it resides, whether it resides in the shape or the configuration or the ornamentation. So that statement of novelty, you have to provide it in the representation sheet. And you have to include a disclaimer if the article has any mechanical action, or if it has a trademark, then you have to provide a disclaimer that you are not going to claim that, you are going to claim only the design of the article. And then claiming a priority date. Priority date is the first filing date. See, I have filed in US and then I want to file in India. Okay, then I can claim the first filing date of the US for the registration. Then what is the fee to be paid? So normally it is 1,000 for individuals, and other than individuals you have to pay 4,000. That is official fee. Then see that all the enclosures are attached properly. See, if you are filing through attorney, you have to file the power of attorney. So you have to see whether all these enclosures are attached properly and send it to file it to any one of the patent office. And prosecution is normally done by the Kolkata Patent Office. So first they will see formally they will see the application. So any objection they immediately write to us or even call us. So it is very much necessary to give the proper details of the applicant or the agent. So if you comply with the objections, and there are designs granted even in 40 days. So these are the 5-10 steps which we have to follow very critically. As I said, you can file in any of the 4 patent office, but prosecution is done by only the Kolkata Patent Office. Why you have to register a design? Is it necessary? Yeah, so for 3 reasons. One is that if you want to get an exclusive right, you have to register it. And if anybody infringes your design, if you want to take action, then only the registered design is can be produced in the court of the law. So you have to go for that. And again, when you want to commercialize your design, so either you want to license it or you want to sell it or assign it, then registration is a must. So these are the official fee. 1,000 rupees for individuals or startup or the small enterprise, and for others means which include the private company, all those things. So they have to pay 4 times of the individuals or the startups. I have just given a few examples of industrial designs registered and in the engineering field. And you can see in communication, if you see, these are some of the different designs of antenna which have been registered. And again, you can see the parts of a computer, monitor, a mouse, a router. So these are all different designs of the parts of the computer which have been registered. And again, the shape of the design of the motor vehicles. So not only the vehicles, and also the individual parts of it also goes along with this. And if you come to in the field of electrical department, you can see some sockets, connectors. These are also eligible for design registration. And smart bins are also been registered. And even the COVID accessories have also found a place now in the design registration: oximeter, mask, and sanitizers. So having seen about that design registration, we'll move to the trademark filing. So as I said, what's a trademark? It's a mark which has to be represented graphically, and it is capable of distinguishing the goods or the services of one person from those of the other. It can be a device. Device is that a combination of a word and a logo, or it can be a label, ticket, word, letter, numeral, or a sound, smell. So anything can be under the trademark registration, or a combination of also. Again, the question arises whether I have to register my trademark. As I said, for design, the same reasons. See, if you want to get an exclusive right, you want to initiate your infringement, and again for claiming priority for foreign protection, you have to register it, and to issue public notice to your claim of ownership of the mark, registration is a must. So what are the basic conditions for the mark to be registered under the Trademark Act? Only 2 conditions are there. One is that it should be distinctive and not deceptive. So distinctive means it should be distinguishable from the existing designs. And not deceptive means you should not, that sign, the trademark sign should not confuse the consumer or the buyers. What type of marks cannot be registered. See, confusingly similar marks, which are visually and phonetically similar to the earlier marks. And the marks that hurt the religious sentiments, marks that are scandalous or obscene, any emblem or name of the personalities, and the shape of the goods which can obtain a technical result or which give substantial value of the goods are not eligible for registration. So who can file, where to file, and what are the contents of the application? See, who can file? A company, an individual, a trust, Hindu undivided family, society, partnership, LLP, or any other entity which is formed under the central or the state statutes. And where to file? In 4 patent office, and also you can add Ahmedabad also. So you should file, and this depends upon the place of the applicant or the agent. So based on that, you have to file it. So if the applicant name is in Karnataka, then they have to apply in Chennai only. So depend upon the place of the agent or the place of the business of the applicant, they have to file in any one of the 5 trademark registries. So what are the contents in the trademark application? So they will ask the basic information, your name, nationality, address. Then you have to specify your trademark. So whether it is a word mark or a device mark or a sound or number, you have to specify it, and you have to represent design. Here also you have the nice classification, and there are 45 classes. So you have to identify to which class your trademark belongs. And also you have to describe the goods or the services for which this trademark is going to be applied. So these are all the basic informations that are asked in the application. And this is the trademark registration process. So before filing the trademark application, you have to do the trademark search. See, to find out the distinctiveness of your trademark, you have to do the trademark search. See whether it is already existing or not. And once it passes that distinctiveness, you can file it online. So immediately you will get the acknowledgement of your application with the trademark application number. Within 45 days, the examination report will be issued by the trademark registry. See, if there are objections in the examination report, you have to respond to it, and you can also ask for an hearing. And this will pass through the, and if there may not be any objection also, directly they will accept it also. So once they are accepted, they will publish in the trademark journal and wait for the opposition to file any opposition. So if there is no opposition, then that certificate will be registered. And if there is opposition, then again the parties will be heard for an hearing, and then they will decide it. And if it is refused, you can either review it or you can appeal to this. IPAB board is no more existing. So you can appeal to the IP division of the Delhi High Court now. And again, in the hearing also, in the examination report, if there are objections, you can write the response, and you can also ask for an hearing. And based on the discussion with the registrar, it may be refused or it may be accepted. So if it is refused, again you have the chance to appeal to the IP division of the Delhi High Court. So again, when to use this mark TM and R. See, this TM is generally used in this stage. See, once you file and you get the acknowledgement of the application, you can use TM, and then you can use it that word trademark name in your business or in academically. Say you can do that one. And once this certificate is registered, you can use R. Till then you should use only the TM. This is the statutory fees or the official fee for filing trademark. It is 4,500 for individuals, startup or a small enterprise or a small entity. And for others, means which can be a company or a trust or a partnership firm, they charge around 9,000 rupees. So we generally know that trademarks play an important role in the business. So what is that it is related to academy? Any ideas from you people? Can you share with me? Unmute and you can share. how trademarks can be relevant to the academic institutions or even for the engineering students. Any idea from the participants? Am I audible?
Yes, ma'am.
Yeah. So as I said, you know that trademarks play a very important role in business. So how can it be relevant to the academy? Have you seen your college logo? Oxford Engineering College name, logo. Whether it is registered already under the trademarks. Hello?
Yes, ma'am.
Yeah. See, you any inputs or any ideas from participants? Okay. See, how it is going to be relevant for the academy people is that, see, first your college name with the logo. See, you know that if you don't register it, people may use the same name and then exploit your reputation of the college. So it is very much essential to register your college name along with the logo. So in the fundamentally this trademark plays an important role in the academy. That is one aspect. The other aspects are like say for the engineering students or any matter, whoever comes with a product, like for example they come with a mechanical car, hybrid car, or so they normally try to name it, so that name can be again protected under the trademarks. And recently also one of the colleges, one of the students, they developed a computer game and they gave a name for that game, and again they went for the trademark registration because that name of the computer game is very much important. So these are all the prospects of trademark in the academy. Much is not there as it plays a major role. See, patents, trademarks, copyright, these are all the three patents, copyright, and designs. These are the three major IPs in academy. So as far as trademark is concerned, much is not there as they play a major role in business. But these are all the other very smaller areas where it can be used in, like registering your the name of the college with the logo, and any product they design and then they come with the name of it. That name is very much important to be protected under trademarks. So it can be a computer game, or it can be an hybrid car and or a EV vehicle, or but for that they come with some windmill or something else, whichever they come, for that they give a name to that product, so to be very distinctive from the existing products in the market. So for that trademarks play a very important role. These are the things which has to be used by the academic institutions. So now let me wind up this session, leaving this thought to you. And now the session is open for question and answers. I will be very happy to answer to all your questions. Thank you, one and all.
Participants, if any queries, you can unmute yourself and ask ma'am, or you can even post it in the chat box.
Let it not be related to even trademarks or designs. You can also ask questions, anything related to any part of IPR. Can be a patent or copyright, any facet of IPR. Not that we have to restrict to the designs or the trademarks which we have in this session. No questions?
Ma'am, maybe 1 second, ma'am. No,
Yeah.
ma'am, we don't have any questions as of now. But if any of the participants mail us the questions, we will contact you offline, ma'am.
Sure, sure. You can mail to me also.
Yeah,
I'll be very happy to guide them.
sure, ma'am.
Thank you. Thank you very much.
Yes,
Thank you for giving me this opportunity. Thank you very much.
yes,
Yeah.
ma'am. So on behalf of the
Thank you.
management, HOD, principal, staff, and students, we thank you for the session, ma'am. It was a wonderful session. Thank you so much, ma'am.
Thank you. Thank you. Thank you very much. Yeah.
Participants, kindly stay in the meeting. We have one more session right now, so kindly stay in the meeting. Ma'am, you may kindly exit now. Thank you.
Yeah. Thank you.
Aravind sir, good afternoon sir. Shall we start with the session sir?
Hi, good afternoon. Yeah, I think I'm just about, I'm trying to set my screen.
Yes sir.
Can you just let me know as soon as you can see the presentation?
Sure sir.
Is this visible now?
Not yet, sir.
Okay, just a minute. It's still not visible, right?
Yes, sir. It is not visible.
So I am trying to share my screen. Because I have enabled my share screen.
Yes, sir. Now we have shared the screen.
Okay, so now you can see it.
No, I think once your video is on, go to that share tracer.
Yeah, I've gone there and I'm saying share screen. I'm clicking on share screen. And I've chosen that application also, the PowerPoint.
You can select the first option, sir. Desktop or window. Open the share tray.
Yeah. So I have three options. It says share photo, share video, share screen. So I have enabled the share screen option.
Okay.
And so now I'm, and there in that share screen, I've chosen PowerPoint.
Not visible, sir.
Okay, let me. Sure, why this is happening. I have shared the screen and I have enabled it, and okay, what I'll do is let me very quickly email this presentation to you. I'll just jump out and email and I'll come back. Okay?
Fine, sir. Fine, no problem.
I'll just do that, and then if you are a presenter, then you can click through it as I talk through.
Okay, sir. Fine. That is also.
Yeah. Sorry about this. I'm not sure why. Sometimes technology just doesn't work for us.
No problem, sir. No problem.
Okay, I've just sent it to you. So
fine, sir. We'll download and then we'll share.
sure. I'll also try to be quick during this entire process so that we stay on time. Yeah.
Is it visible, sir?
Yeah, now I can see it. So thanks for this. And good afternoon, everyone. I think it's been a slight delay, but now we shall get back on track with this.
Sir,
So as I understand you.
the interruption. We will introduce
Sure.
you to the participant, then we will resume, sir.
Oh, okay, sure. Sorry about that.
Okay.
I got a little.
Good afternoon, everyone. We would like to introduce the speaker of the session, Dr. Aravind Viswanathan, who is a technology and IPR consultant with several years of experience developing and protecting technology in a wide variety of domains. He serves as a consultant for a number of early-stage technology startups as well as business development consultant to IPR service firms. Earlier, he was the Director, IP Analytics at LPO Legal Advantage LLC, leading a team of patent analysts, and before that, the Chief Strategy Officer at Select IP Solutions, Bangalore, India. In this role, he is actively involved in providing end-to-end IPR consultancy services for clients across the world, including technology and patent search and analysis, patent drafting and filing, and advisory services on several different aspects. He is also deeply involved in providing IPR-related training. To that end, he has been involved as a resource person in a number of training sessions, including several programs. He has also drafted several patents in many different technology areas that has been filed and granted in several jurisdictions. With a short introduction, we would like to welcome Dr. Aravind Viswanathan to the session. Sir, on behalf of the college management, principal, HOD, staff, and students of Department of Biotechnology, we welcome you to the session, sir. It's over to you, sir.
Thank you very much. And like I said, I had jumped the gun a little bit ahead there and got a little too anxious to get started as we are running short of time. But I guess now we can, keep on schedule and make sure that everything's going well. And first of all, thanks very much for the kind words of introduction, to all the faculty. And as I understand, everyone here has been going through, it's like almost a week-long program that you're going through to understand how IP is going to be useful during the course of bioinnovation and in the agri-tech business and agri-tech areas. So it's a very important facet, and I'm pretty sure you've already been through some of the things that I'm going to talk about, and a few other things I'm pretty sure will be new to you, and I hope to give a different perspective, even if it's the same concept that I'm going to talk. And, starting right off the bat, there's a lot of innovation that's happening, and bioinnovation is one of the need of the hour. And I'll show you a few examples as we go through this entire session about where and how biotechnology is playing a huge role. we are living in this so-called VUCA world. VUCA stands for VUCA, which is volatility, uncertainty, and all those kinds of things that's driving this entire planet. We're not sure where things are going, how things are going to shape up, what the future holds for us. Is there a future at all for human beings as a species or the planet as a whole? These are very big questions that in the past only philosophers used to ponder about, but now it's becoming a reality for most of us that even a child growing up in any remote part of the world or in the largest metropolis, they all have to consider these questions. And as we keep moving along, progressing towards greater and greater industrialization and expansion and larger production and manufacturing and things like that, we are also coming across more and more industrial level problems, which requires much bigger and greater solutions, or it could be smaller, traditional kind of solutions. It could be any number of things. At the end of the day, all of us have to start innovating and putting things in perspective and solve a lot of solutions, solve a lot of problems, provide solutions that is applicable in a given situation, either locally or globally. And when that happens, it usually happens through a large expense of time, money, intellectual capacity, a whole bunch of team coming in, working together, a whole lot of things that go together. And when that happens, everyone needs to organize themselves in a certain manner to, affect that solution, to put that solution in place and provide this opportunity for the world to enjoy the benefits, reap the benefits of the solution. And obviously, when you organize people to do something, there's also a remuneration that is involved. Why would I have to work with you on a certain solution, on solving a certain problem? Because you're compensating me for the time. So when you do that, when you're organizing people to come together, then businesses are involved. And when businesses are involved, there is also the requirement to at least meet the business requirements. Whether it's defraying the costs of the development and ensuring that the innovation is, actually being put in place, and taking the solution to the market, whether it's marketing, things like that. There's a lot of costs involved, and it's not necessarily profitability that comes into matter, but everyday running costs, paying bills like electricity and office space and production and manufacturing, so that a farmer, so that somebody somewhere who's going to benefit from this, the parts, the products, the components that you're manufacturing will reach them in a reasonable amount of time, so that the planet and everything that you're trying to save, actually it becomes more meaningful. That in essence is what this whole thing is about. And so when you are looking at something like that, you also have to make sure that your idea doesn't get taken away by someone else very easily, because ideas are just that, an idea. And someone else looking at you is going to say, well, if that's what you're doing, then I can also do the same. And they don't have they have the luxury, the copiers have the luxury of taking the best version of the product that you have in place and providing it to the market, which means their costs are obviously going to be less when they put the product out. So all the time and effort that you spent in organizing people and resources and time and all the labor and all the capital investment you have made will all go to waste. And the best way to protect yourself against such wastes will be the use of intellectual property rights. And I will focus a little more on patents as we go along. If we can move to this next slide. But Just to let you know, there are a total of 8 different intellectual property rights available for anyone who is trying to use it. And not all 8 is useful for everyone. In fact, different technical domains will have different levels of, different kinds of IPR that would be useful. But generally, when you are involved in technology development and protection, patents are always a useful tool. When you are in the market supplying something and you're trying to establish a name for your product and for your company through the product or a service for that matter, then trademarks are useful. When you have generated some material, some presentations, some advertisements and hoardings, things like that that you do, those are all copyrightable materials. Any product which has anything that has an aesthetic shape or an ornamental design associated with it, not necessarily technical or functional, but just aesthetic design, then those are protected by industrial designs. If you're involved in any kind of chip manufacturing, then the integrated circuit layout, which may not be necessary for your situation. When you're developing newer kinds of plant varieties, which I'm sure you have already heard or you will be hearing over the course of the few days that you're going through this session. Basically, it has to be a distinct plant variety from what already exists. It should be unique, and it should be capable of reproduction, sustainably and in a stable manner. So then you can go in and get protection for the plant varieties also. And those of you who are closely following the news will be aware of a new plant variety that was protected by, I believe it was Monsanto. It's basically sorry, not Monsanto, the Pepsi. Who had licensed it to a company here, and then they had the plant variety for potatoes that is specific, to be used to make the chips, the Lay's chips that we all buy a bag of chips when we are very hungry, when we are, I don't know about you guys, but anytime I'm in the mood for anything, those Lay's salt, especially the salted Lay's chips, I love those things. I'm not a big fan of the masala or the tangy cream or anything, but those salted chips, I really like them. And so they basically had farmers in Gujarat, they gave set of seed, one particular plant variety, which they, use the farmers to plant the potatoes and grow it only for them. But then there was some controversy, and I won't get into all of those details. But now that plant variety has been given to the public domain, so to speak, so those farmers can grow that potato and sell it to anyone who's interested, who wants that potato right now. And last but not the least, you have trade secrets. Now, trade secret is a very unique form of an intellectual property right. You say all the other 7, one of the reasons why I have shown it in this manner is because the other 7 forms of intellectual property rights garner protection only on the basis of filing with the relevant office. So patent has a patent office, trademark has a trademark office, copyright has a copyright office, so on and so forth. So there are specific offices with specific rules, guidelines, laws, everything that is that is used to govern those kinds of IPRs. But trade secrets, while there are laws related to it, there is no particular office. The secret is protected by virtue of you protecting that particular information within your organization, and even within your organization, only a certain few people would be aware of it, would know that that particular information, and no one else should be given access to that information. There are several examples, but I think one of the most famous ones is the formula for the Coca-Cola drink. That is a trade secret that's protected by the Coca-Cola company since 1880 something, 84 or 87 or something. So it's been like what, 130, 35 years now that they have protected, and in principle they'll be protecting it for the next 1,000 years for all we know. But that's the big difference between trade secrets and the other forms of intellectual property rights. So this depiction is just to show that this, whatever you come out with as an input to this prism of IPR, how creative you get, how innovative you become. You put it through the IP exclusivity prism. The trade secret will contain it within that, prism of IPR, and it won't reveal it to anyone. While all the other forms of IPR will be shown to the respective office, who will then go ahead and put it in the public domain for everybody to see, understand, and know what exactly you own in terms of that particular intellectual property right. So if you move to the next slide, we'll talk more about patents. So what exactly is a patent? You can click through all of these. Yeah, I'm sorry about the slide. I don't know why it didn't. I can click a couple of more times because each one is each bullet point is a yeah. So this patent is basically given as an exclusive right, for a fixed period of time by a particular jurisdiction for whatever you have disclosed to them. Okay, so once you write that patent document in a manner that that is required by that particular office, whatever is disclosed to them will be made public, will be made obvious, or to lay open, which is what the word patent means. And for that particular disclosure, the protection is given for a fixed period of time. And it could be anything. It could be any process, machine, article of manufacture, a new composition, any number of things that's out there. And we'll see in a little bit what are the specific things that you will get. And it's not just any new and useful process or machine or anything like that. It could also be any improvements thereof. So if you have improved on that, an existing composition or a machine, or some kind of a method of doing something, then even that gets protected. So if you can move on to the next slide. So as I mentioned, there's the incentives are pretty clear. One of the main things is, you have to protect yourself against any kind of copycats. And, we in India should not be we should be very aware of some of these things, because we have thrived on for a long time. I wouldn't say it's right or wrong. I don't want to get too judgmental about this. But knowing what is very successful and then just copying and using it has become a kind of a way of life for us for a long time, especially for some of us who lived through the 70s and 80s, when we've seen so many of these successful innovations come to market in India. Like, back then you had Nike shoes were something really new. And so, somebody sitting somewhere in one of these remote locations saw that when you have a shoe, and then when you have the shoe with that Nike symbol on it, it sells better and it sells for a bigger price. So he just started manufacturing shoes with that symbol. But not knowing what intellectual property rights and that swish, Nike swish, is actually a trademark and things like that. So one of the main things is to understand that whatever you're doing needs to be protected in a certain manner, and so you yourself also have to be aware and respectful of others' intellectual property right. The other thing is, for specifically for patents, you are coming out with these ideas, and logically speaking, these are highly useful ideas. Otherwise, why would you go ahead and do it and try to protect it? It's not something destructive or anything like that. And it is supposed to improve somebody's lives or a whole community, or it's going to do something good. So it puts that idea in the public domain. And just because you've done that, the state, the jurisdiction is giving you, a time period during which you monopolize it. But after that, that idea is available for the public, which means that anybody, who's in that field can take it and start selling that product. Now, this is a very big factor. So it's not like, that thing is going to be your property for perpetuity. Nothing ever is. Okay. So the public record is a huge thing. And so, something like a good knowledge will never be lost to humanity, because there is a clear evidence of a track record, a public record that shows what has been done and how has it been protected. If we move to the next slide, you'll see that, in biotechnology specifically, there are a number of things, that are happening in the recent past. And we can just skip through to the next couple of slides. That's fine. You can go past these basic definitions. I won't really bother. So, okay, you can skip past this also. So, I'll talk about this and then I'll loop back to that point about why in biotechnology, because there's so many things that are happening, but that requires a lot of important developments, and so you need the protection. But as I was telling you, there are time periods for different forms of IP, like trademarks and geographical indications you can include in that. Those can pretty much last forever, whereas copyright is 50 years from the expiry of the author, or if it's an orphan or anything, then it's 50 years from the date of publication. But patents are basically 20 years from the date of filing, after which it's available for anyone to take it up and use it. So some technology that was developed back in, let's say, even 1995 or 2000, would have expired in 2020, which means in 2021, I can take the technology and start using it. So there's a lot of good things about intellectual property rights that we can't ignore, and we should be utilizing it in a particular manner. You can skip. You can move to the next slide. Okay, so these are some few examples in everyday life that we see. Like I'm sure you've all seen. BT cotton, I think cotton that grows in, I believe, drought-resistant conditions or pest resistance. I think it's been in part with some pest resistance. Brinjal, I think, has been very famous. It's been a long time since we had that. We have the drought-tolerant versions of several plants. There was a Golden Rice project, which incorporated rice, which incorporated vitamin, God, what one was it? Vitamin E, vitamin D, one of those vitamins into that rice. So basically the rice had that vitamin built into it. So these are a number of examples in our everyday life that we see on a regular basis. I don't know if you're aware of it or not, but and I also mentioned about the potatoes, the Lay's chips. They are all the bag of chips that you buy today basically are coming from some biotechnologically modulated, I would say, product for our benefit. And it's not just improving crop yield, crop production, but biotechnology is also going one step further in using plants and crops and things like that to change the environment. For example, the phytoremediation, where if a soil has become so toxic or has too many heavy metals or anything like that, there are some crops that have been specially modified or modulated. Their genes are modulated to the point where it can actually attract the phytochemicals, these heavy metals, into their system, so that it takes up. There is an uptake of these heavy metals into the plant, which can then be used to mine or process to extract those heavy metals for other uses, and the soil also becomes more nutrient rich and things like that. So so it's gone just from making something more productive, more higher yielding, down to changing. These phytoremediation is a huge field where air pollution is being cleaned by using these plants, these genetically modified plants, to extract these pollutants directly onto the plant, and then the plant is those pollutants are then cleaned out by the when the plant is being processed or done something else. So many other things are happening right now as we speak. Terrace gardening, which involves a different kind of a plant variety that is being developed right now. There's so many things that are happening which are improving our lives, so to speak. And so this dim, bleak future that we keep hearing about when you turn on the news about this environmental and pollution and global warming and all that is also driving a lot of developments in biotechnology. And it, I would say, it necessitates this kind of a development right now as we speak, because if we don't have these things, then we may not have a future. But thanks to biotechnological advances, we do have these possibilities in place. So move to the next slide. We'll delve a little bit deeper, so into some of the legal things that are pertinent to our situation. So move to the next slide. So this is the basic, TRIPS agreement. TRIPS, I think I might have heard. It stands for Trade-Related Intellectual Property Rights Agreement. That was signed by some 100, pretty much any WTO, some 190, 92 countries or something like that. Anybody who signed WTO agreement and wants to be a member of WTO has signed this. And there, they have several articles, and in Article 27, they have said some few things. You can give a patent to anything, any invention, product, or process in any technology, as long as they have three things: new, involve an inventive step, and capable of industrial application. And then they went on to say that you may exclude a few things, like something that may cause, some disorder among the public because of its very presence, morality. You can also exclude, things, diagnostic, therapeutic, or surgical methods of treatment, and other things that are there. You can move to the next slide. And I'll get into all of these details in the next subsequent slides. And like I said, I don't want to get too caught up in this. Let's move to this next slide. I have a whole set of, let's keep moving. A whole section, one more. Yeah, so in this section of this presentation, I'll be talking about how it applies, because it's like you see all these relevant laws and section 3A, section 3B. It looks cut and dry. So instead of just walking you through those sections, I thought I'll just give some explanations or examples to illustrate what that particular section means. So the next slide starts with the first example. Yeah, so this is, Claude Shannon was one of the famous inventors. He's an electrical engineer or something from way back in the 1920s, 30s. And, he had this, he was a professor in MIT, and he was the one who built one of the first early forms of computer. So he had this box that was basically featureless, just possessed a switch. So when you hit that switch, the lid will open, and a mechanical hand will come out and flip off the switch, and when back, that hand will go back inside the box. If we click once more, you'll see that something like this may not be patentable in India, because we have a clause in section 3A. Just click once more, please. Yeah, invention which is frivolous or lack of a particular application does not have a useful, concrete, and tangible result. There's nothing very technical about it. All the technology built into it, the switch, the mechanical arm, the electrical connection, everything, that's all known. It's just putting things together in a certain form that is generally frivolous. So the chances of something like that being patented today in India would be very low um, because this would be considered considered frivolous, and under section 3A it might be rejected. Okay, so this is just a quick example of how this particular section and what that statement there means and how it might be applied to the situation. Similarly, in the next slide, I have another one of Claude Chan, and he was, he was a prankster apparently, where he came up with something like this flame throwing trumpet, where it's like if somebody picks up that trumpet and blows into it, it'll shoot flames from the other side. And so he would actually do it to the band, the MIT band, without their knowledge, and then watch the whole thing unfold with some fun. And now, as I told you, it's like members may exclude from patentability something that will be blah, 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 it's like all that. Now, an invention like this, if you click once more, may be rejected under section 3B, which states that the primary or intended use or commercial exploitation would be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life or health or to the environment. So something, so this is what this section means. It's like if I take it and use it, it could actually destroy. And so it's like I can't grant a patent for this particular invention. That's what it says. That's what that section means. Similarly, the next section, section 3C, basically says that if you have something like this, it says it's not an invention. What it is it's basically a theory. Okay, so theories, abstracts, principles, these kinds of things cannot be given patent protection. Any application of the theory to make a machine, an apparatus, anything like that, that can be protected as an invention. But theories as such, they belong in papers and publications. You can have that. And if you can attach your name to the theory, then great, Moore's law, Einstein's law, Newton's law, have those kinds of things. That's all great, but not patents. Simple as that. So, this is something that I came up with as part of, I don't know what I was doing, but I thought, hey, this is what is happening. And so that's why the surface temperature is increasing. It's a great theory. I don't know if it's valid. I don't think it's valid. Doesn't matter, but it's a theory nevertheless. I can't get a patent for this. And I hope somebody proves this and then tells me that this is Arvind's law of global warming or something like that. We'll see. Anyway, move to the next slide. Get past this to, then we also have something like this, something that's commonly occurring in nature. Even if it's not commonly occurring, if it's just occurring in nature, then you don't get a patent just because nature has it. You might have found something for it. You found that iron 56 is commonly occurring, but iron 60 works better. But it still is iron. You can't patent iron 60. You can patent a magnet that uses iron 60 instead of iron 56. You can patent some kind of a device that uses that iron 60 or something like that. But iron 60 in itself, by itself, you can't patent it because nature has given it to us. We can use it freely. Any human can use it. Okay. Any discovery of any living thing as such, unaltered, is not manufactured. Anything that happens is not allowed for patent protection. Okay, moving on. Then you have this, you take two things that are present, that are already known, and you're combining both of them to make a single product, but each of them act independently, then it's not allowed for patent protection because they are acting independent. These are two separate inventions, and once you put them together, they are still acting as two independent inventions. There is no combination there that is working. Because of this combination, you haven't made any synergistic effect, anything new, anything different. You've just put two things together, not a patentable invention. Let's move on. Okay. Okay, so this is another very common thing, and especially considering today's, one of the principal features of this entire session is IoT, Internet of Things. It involves a lot of software and applications and aggregation of data and things like that. So aggregation of data and utilizing the data to produce information and provide knowledge, which is one of the big themes of Internet of Things, involves a development of a lot of software and algorithms and taking the data and processing that data in a particular manner. And so this involves a lot of technology and technical developments. And one of the big questions that come out of this is, this algorithm or the software, is that patentable or not? And so this is, I've given this as one example of a claim that somebody had actually attempted, drafting into a patent and filing and getting it granted. The answer to the question, patentable or not, this, if you read this claim, it basically says that this model for this inhibitor, it takes this particular crystal structure and links it to something in there and assigns bond orders and does a lot of calculation at the back end of a computer. And then based on the calculation, it's going to give an output as to whether this particular compound can be used as this AC inhibitor for treatment of CNS stands for central nervous system disorder. I'm guessing some kind of mental disorder, central nervous system, not sure. Okay, but that's all it is. It's a software to do some some things on the computer. Can we patent this or not? And then the bigger, broader question is software patentable? The answer is no. Software per se is not patentable. However, a particular technical development and a method for using it and applying that particular software for a technology and answering some technical questions, it is patentable. So this particular patent was actually allowed in the Indian Patent Office. So if you click, it just says exactly that at the bottom of the slide once you click into it. Right? Can you just click once? Yeah. So this is what software patents is. So you can't solve business problems, okay? Business problems, business methods and all, they're not allowed. But what you need to be showing is a technical effect, and so that obviousness criterion or the inventive step criterion becomes very high, meaning there's so many things that you can automate using a computer, and once you automate some things, it also facilitates a few extra steps which you may not have thought of when you were doing it manually. But just because though you have facilitated those steps does not allow you to patent them, because it's an obvious outcome of facilitating steps. And so that obviousness criterion becomes higher. And these are some of the, the KSR versus Teleflex is one of the important cases that established this criterion in US. And I won't be talking about this particular case, but I'll be bringing up some other case laws. But just to give you an idea, case laws are extremely important in that it establishes how a particular, an invention can be fought and can be protected. And so when there are ambiguous questions like what is obvious, what is inventive step, what is the criterion for this, how do they determine this, that, or the other. Case laws are the ones that will establish some of these parameters. And so going forward, we know that this is the gold standard for that particular criterion. And so we can, then see which side of the standard it falls under, and then you'll know whether it can be patented or not. And that's how the obviousness criterion has been established in the US, and a lot of other countries are using that particular criterion. So if we move to the next slide. Can we move to the next slide? Yeah. So, and another aspect about, especially in this field is also there's a lot of traditional knowledge that is present in our communities. Now, these things cannot be patented because it's traditional knowledge. It's already known to that particular community, village. And so, in principle, at the very least, it's applicable. It is to be used by that community for free. And so, by virtue of that, the whole planet can use that particular knowledge. It's already known. It's something that has been there for ages, for generations. It is past its statutory time limit of protection, and so you cannot exclude them or anyone else for that matter for using the traditional knowledge. Okay? And there are so many other unpatentable subject matter which may or may not be relevant for this situation, and I won't go into that. But this, in essence, is the unpatentable, the sections, the section 3, which tells you what is and isn't patentable in India. And so I thought I'll just give you a little bit of a flavor of what they are and how they might be applicable to a particular situation. So if you go to the next slide, we'll move to the next section, okay, which basically I talked to you about some of these things, the criteria of patentability. So when you file a patent application with the patent office, one of the first things the examiner is going to see is whether it falls under any one of those statutory non-patentable classes that I already mentioned. Okay, will it fall under 3A, 3B, 3C, 3D, so on and so forth. And only if it does not fall into any one of those unpatentable subject matter, then they'll go check for whether it's completely new, whether it's already known, is some part of it known, is everything known. If part of it is known, what is the unknown? Is that unknown something that is very obvious that anybody could have arrived at it? Is it inventive enough? And then that industrial applicability or utility usefulness. And these are three different things. It has, in the legal terms, there is a very clear distinction between being useful and being industrially applicable. The US law, as I understand, goes with the utility or the usefulness, whereas pretty much the rest of the world goes with the industrial applicability as a requirement. Okay, so move to the next slide. Now, armed with this information, now we can actually start looking at things, with greater detail. And as I mentioned, if we move to the next slide, please. Yeah. So as I mentioned earlier, I was talking to you, about some important case laws, and one case law that I did mention was the KSR versus Teleflex, which is used to establish the obviousness criteria. And it's an old law by now. It's about 10 years or so, but it's still relevant and useful. But some of the case laws that I will be discussing here are even older than that, but they are all highly relevant and useful for the biotechnology situation. So one of the first things that I'll discuss in the next slide is related to a landmark case for a particular biotechnology application. which involves the use of, in the next slide, yeah, which involves a genetically engineered bacteria which can break down multiple components of crude oil. So if there's an oil spill, all you have to do is send that bacteria into that particular place, and it will suck out all the crude oil from there, and it's capable of cleaning up that entire area, so to speak. Now, here they were. The patent office was presented with a very unique situation. For the first time, they had to deal with a living organism as a patentable subject matter. Should we or should we not do this? So there was a lot of debate, and initially they said, okay, method of producing the bacteria, that's fine. You're genetically altering the bacteria in some way. Inoculum comprised of a carrier material floating on water and the new bacteria. That's great. That's fine. That's using a living organism to clean something that's new. Even that, after a lot of debate, they finally allowed. But the bacteria themselves, they said, living things are not patentable under the examiner's interpretation. This happened in US. So, and at that time, the Court of Customs and Patent Appeals, which is now changed, this is CCPA, it used to be there. Now it's federal circuits and things like that. But they reversed this decision and said that the bacteria, the microorganism being alive, is not legal significance. Okay. And so, for the purpose of the patent law, there has been a human intervention which modified the bacteria from its natural state. So, it's not natural living, it has to be artificially man-made, and so it can be allowed. And so they allowed the patent for the bacteria itself after a lot of debate. It went through some 10 years of debate back and forth for a lot, and finally they allowed it. And this was a landmark case. This was the first time that a particular microorganism was given a patent protection. This opened the doors, and then if we move to the next slide, we had an even bigger, more unique case. Okay. Can we move to the next slide? Yeah. So here we had the situation of an oncomouse. Now, about in the mid-70s, sometime there was discovery of the so-called transgene or the oncogene. Okay. So, this was identified as the one that was related to cancer and causing cancer and treating cancer and things like that. And then the Harvard researchers, they took this transgene and took a mouse and purposefully introduced this transgene into that mouse. And they started producing these genetically altered, modified mice, which is, contains and expresses this oncogene repeatedly. And these animals were extensively used to study cancer and test anti-cancer drugs and things like that. So suddenly this became, when they said that just because a microorganism is alive does not mean it's not patentable under the patent law. Now they said, well, if being alive is immaterial to the question, if man-made introduction of these genetic material artificially by humans, if that's what it means, well, then this mice should also be allowed. And this became extremely controversial. There was a lot of moral and ethical issues associated with this, because where do we stop? Is it just mouse? Can we go ahead and start patenting these humans and anything like that? And so there was a lot of debate, and this was back in 1984. And there was a lot of debate. It went back and forth. There was a decision to allow it, then it was reversed, then it was allowed, it was reversed. And in different countries, they took different stance, different position. We move to the next slide. So there was all this history, and then 88 initially they granted in US, where they said, fine, you can have any non-human eukaryotic animal. Okay, so as long as it's having this, but in Europe it was rejected. You know, it went through a lot of debate and opposition by several people, and finally they said we limit it to mouse. And you know, it was reviewed again, but then they said no, we won't limit, we won't allow any of those things, and finally they let it lapse in 2001 after a lot of debate. So then Europe, the European jurisdiction went through, you know, a lot of soul searching, so to speak, and to find out what exactly is this and what happens if we start getting more and more these kinds of new things, new animals that are genetically modified and changed. So in 1999, the EC, the European Council directive, was implemented, and where they said that, you know, microorganisms like fungi, algae, bacteria, these are all allowed. You know, we are going to allow patents on them as long as there is it's not naturally occurring. It has to be genetically altered or with a specific purpose in place. And there also needs to be, you know, proper disclosure and how this is going to be involved, and you know, how the whole modification has to happen. And in situations, and in many, if not all situations, a sample of that genetic material or that or that organism has to be given to a local authority, you know, somebody who is basically recognized by the, you know, WIPO or the local patent office, you know, whichever is the, you know, prevailing authority in that region. That particular organization should have received a sample of that organism or the genetic material, and they should store it, and they will assign a separate accession number which should be available for anyone who chooses to examine this if necessary. These are some of the things that you know, that came out of this entire history of the mouse trying, you know, genetically altered modified mouse being protected. And in more recent terms, you know, we have these kind of CRISPR-Cas genes, excuse me, which I think you know, many of you would be aware of, where using this CRISPR technique, you can selectively modify a specific gene in anybody, for that matter. So, you know, in principle, the original idea was that we can actually have these, you know, any genetic defects can be altered and checked so that people won't be born with these genetic abnormalities or diseases. So those mutations can be removed or replaced with the normal cells. But it's also highly controversial because now that same genetic mutations can be induced in the womb, and you can have these so-called designer babies, you know, babies that with blue eyes, for example, or extra fingers, or you know, blonde hair, or, you know, things like that. And so if you can do things like that, is that ethical? Is that moral? Is that natural? Is it allowed? You know, and but CRISPR-Cas is a highly patented field, and it's a highly controversial field now. And so the debate for something like that is raging as we speak. And you know, and so there's on, and you know, sometimes it's considered to be the right thing to do. Sometimes it's yes, you know, the discussion leans towards no, it should not be allowed. It should be regulated. If it's regulated, what kind of regulations need to be in place? You know, there's so many things that are happening now. Anyway, so that's as a side, but just to let you know that biotechnology is a field with with one of the most raging moral and ethical issues, than any other field that you can think of, because there's a lot of things that are happening that affect everybody's life at a very core level. And if you see even the current COVID-19 virus, it could be attributed to some extent to a big extent to some of the virologists, which would fall under the broad ambit of some of these biotechnical innovations that they are trying to do. So, if the lab leak theory, so to speak, is true and valid, the idea would be that, and it also is probably the plot line of a very bad Hollywood, horror movie. I'm sure I've seen something like that in some Hollywood movie, but basically it says something like, as he was trying to study the virus with the right kind of intentions to, study viral load and do something, but that virus has mutated and infected him, and he went on to infect the rest of the population. And now we have some billions of people infected, so many millions who actually died from it. These are things that tend to happen if you don't contain it and do it properly. But at the same time, we can't really stop research into something like this, because there's also a lot of good that can come out of it. Like I said, if we didn't have biotechnological research, we won't have these drought-resistant crops or phytoremediations, or so many good things also come out of things like that. So, with all this in the backdrop, let's just move through the next few slides as quickly as possible, considering we are pressed for time. Can we move to the next slide? Can we get to the next slide, please? Yeah, so given all of this, then drafting patents, and when you have a biotechnological invention, one of the things you have to do is draft a patent of high importance, and clarity is necessary, and establishing the utility or the concrete tangible result out of that invention has to be spelled out in clear terms as much as possible. Okay, and we've already seen what cannot be patentable, so I won't go through that. And in the next slide, I'll talk about what happens if you don't give the clarity of the concrete tangible result or the utility. So if you move to the next slide. Can we go to the next slide? Yeah. Okay, can we move to the next slide from this? Looks like there may be a lag in, after you click from the time you click to the time it's actually displayed on my screen here. Okay, so anyway, so there needs to be a clear, establishment of the utility and things like that, and along with that, you also, if there are any sequences that are involved, nucleotide or protein sequences, there are a set of given guidelines that you have to follow, and it's called the ST25, or the standard for the presentation of nucleotide and amino acid sequence listings in patent applications. It was established in 1998 and by the World Intellectual Property Organization, and now it's standard across the world, where they have all the rules associated with it. It has to be in the computer readable ASCII form, and you don't really have to worry about it now. There's softwares that do it, and it's freely available. You can click and download it, and then you just put in the sequence and fill in the requisite details, like which which organism and who's the inventor and who's the assignee, things like that. It just lists everything out for you automatically without a problem. So not a whole lot that needs to be done there. So I won't spend too much time on this, just to let you know. So if you move to the next slide, just to let you know that these are requirements, and so when you have sequences, you just have to follow this rule and use the software to list your sequences in that particular format, and appropriately also draft the patent application to ensure that the protection is duly offered, so that there is clarity of disclosure in your patent application. So move to the next slide. These are some of the abbreviations. We'll skip past this also. We'll skip past this. This is how one of the sample sequence listings will look like. And this is USPTO, but pretty much if you go to any patent office and look at the sample sequence listing, this is how it'll look like. There's codes and there's things, and it looks it's very clear as to how it is once you know how to read it. So we'll move past this quickly. Go to the next slide, please. Yeah, so this is pretty much the final, message that I thought drive home. There are so many considerations when you look at this field of biotechnology, and as I said, I don't particularly believe that we humans have any kind of an evil intention. We're not looking especially to harm others in any way. But what does happen is we may not be fully considerations. We may not fully consider some of the external other aspects associated with our work. We are not fully aware of all the consequences that may result from our work. And because of that, when we try to do good, some things, some unintended consequences may result in something bad. And so the burden of this unintended consequence causing something evil is much greater on a biotechnologist involved in heavy biotechnological kind of a research. And so being fully aware is something that is essential for this researcher, because what happens, as the consequence, whether it's intended or unintended, sometimes far outweigh all other considerations in this technology area. And so you have to take everything fully into account before making decisions. And this also includes whether to file a patent or not. For example, this COVID situation has opened the eyes. And so at this point, if somebody were to say that I have a vaccine for this COVID-19, which is highly effective, but I have patented it, so you have to buy it from me, that would basically result in a lot of, I would say, bad consequences for humanity as such. And so, again, the good thing is some of these companies, larger corporations, are fully aware of these kinds of situations, and so they formed this COVAX and said that opened up the patents and allowed them to do this. But still, there were some companies, especially the German ones, who said that they have been they wouldn't be sharing the patent knowledge, but allow manufacture only through certain very specific entities in some countries and all. So there are some lot of controversies, but as I said, these kinds of moral and ethical issues far outweigh a lot of these considerations like patent, whether even that 20-year protection should be necessary, or is it worth waiving this protection also. So, taking all this into account and being very hardened, mature, adult researcher is the need of the hour, and then accordingly proceeding forward and doing the right thing is the way to go. So this is what I had for today in a quick nutshell. In the given time, I thought I'd cover all this information, and I'll be happy to answer any questions. And I'll leave my contact information with the organizer. So even if you don't have the questions now, you can always write to me at any point later, or call me, and I'll be happy to answer. Email is usually a much better way because phone I may or may not be able to talk at the moment, but email is always good, so that I'll look at it and I'll be able to respond to it, maybe not immediately but a little bit later. So anybody has any questions, anything they'd like to share, their particular their own experience or anything like that, this might be a good time depending on the amount of time left for this session.
Thank you so much, sir, for this valuable information, sir. Sir, we are running short of time for the next session. So we will be sharing your mail ID to the participants so that they will get back with the queries, and we will contact you, sir, with the queries.
Okay. Sure.
Sir,
yeah. Okay. Yeah.
Sir, on behalf of the principal, HOD, staff, and students, as well as the participants, we extend your heartfelt gratitude for this thought-provoking lecture, sir. So once again, thank you on behalf of all of us. Thank you so much for accepting our invitation and giving such a wonderful lecture, sir.
Thank you very much for this. I really appreciate it. It was great talking. Thank you.
Thank you, sir.